Good afternoon. This is Dave Henry, and this is the first in a series of presentations called the Mediation Mastery Series. We've designed this program in 10 30-minute segments, and we're going to produce and distribute these segments in 1-hour packages or 1-hour videos that are available for CLE. There's one CLE course number. If you complete the whole course, you'll have a total of 5 hours of CE available to you. It's my pleasure to have the opportunity to talk about this in a comprehensive format. I've wanted to do a program like this for quite some time to give everyone the benefit of my experience as a mediator, a comprehensive understanding of the rules, some ethical quagmires you can walk into, debunk some commonly held mediation myths, and also we're going to talk about some unusual and creative settlements. So by the end of the 10 programs, you're going to find yourself, I think, very well informed about all the things that can happen in mediation, how to deal with problem actors and problem situations, and be a much more effective mediation advocate. I am a big believer in the mediation process. I think mediation provides access to justice, but mediation is a dark art. It is hard to teach because we don't have the same tools available to us that we would normally have as lawyers. As lawyers, we learn by replicating. We get to read a transcript or read a deposition or watch a closing argument or watch an opening argument. And because mediation is confidential and privileged, we don't get the benefit of those lessons. We can't export great mediation advocacy from the mediation itself in the way we could with trial advocacy or other things because it's confidential, it's cloistered proceeding. And so that creates some didactic difficulties, meaning it makes it harder to teach. And so we have to spend a lot of time talking about what should we be doing in the mediation and also the things leading up to mediation. I think if there's a overall philosophy or theory or impetus for this program, I guess is a better word, it would be that we need to do a better job as lawyers preparing for mediation, preparing ourselves, preparing our clients, and preparing the other side. And we'll get into that a little bit more in some of the later programs. But it is not easy to be a good mediation advocate. In fact, being a good mediation advocate is almost is a phrase or a term of art you don't normally hear. And that's because it doesn't create a lot of spectacle. It doesn't build a resume. You don't get your name in the paper if you're a good mediation advocate, but yet mediation is hugely important to the clients and the general public and the system as a whole. If we didn't have effective mediations, our court system would be overrun. And so mediation provides a huge private and public benefit. And it does provide access to justice in a way that the trial system really can't, because trials are prohibitively expensive. Most people don't know that only 1% of the filed matters in Central Florida, and in fact across the state, go to trial. Less than 1% go to trial. So the overwhelming majority of the cases that we bring are going to settle, right? A few will be resolved by dispositive motion, but the overwhelming majority are going to settle. And of those that settle, the overwhelming majority of those are going to settle at mediation. So I always ask the question, why do we spend so much time on the 1% problem we call trial? We have trial schools and trial advocacy training, but we don't do a whole lot in terms of mediation training. And there's socioeconomic factors for that. Mediation's not sexy. Mediation doesn't make you a lot of money. Mediation doesn't enhance your reputation in the eyes of the general public, but it's hugely valuable. But the smart lawyers know that clients appreciate a job well done at mediation. If you have institutional clients or repeat customers, so to speak, they're going to value your skills in mediation much more so than your trial skills, because your trial skills aren't going to be on display. And institutional clients that hire law firms repeatedly don't make their hiring decisions based on trial results. We know this. They've done surveys of risk managers and in-house counsel and claims administrators and folks of that sort. And when they were asked, how do you choose law firms to do your work? Only 1 or 2% said trial results, because there aren't enough trials to be able to compare law firms. We don't try enough cases. The cases aren't similar, but what they do have data on, what the large institutional purchasers of insurance carriers, other large companies have, what they do have data on is they have data on settlements. They have data on how much indemnity do we pay? What was our recovery? How long was the file open? How much time did we spend between the time the file came in the office and settlement? That's data that they have. So if that's data that they have, that's the data that they're going to use to compare law firms. And so if you can sell yourself as a trial lawyer and as an effective mediation advocate, you're going to distinguish yourself in the marketplace. I'm always somewhat surprised or find ponderous these law firms that have these websites that are very trial centric, in terms of their ability to aggressively prosecute cases to conclusion. Well, institutional purchasers of insurance services, legal services, don't want to go to trial. Trial is a last ditch scenario for them. That's at the end of the day, if we have to, we will. There's very few clients who actually want to go to trial, even though those that say they want to probably don't really want to if they really knew what was going to happen. They tend to be more unsophisticated. So if you're touting yourself as an outstanding trial lawyer, but ignoring your mediation and settlement skills, you're touting something that's only going to happen 1% of the time. And you're touting something to clients who really don't have much interest in going to trial. What they have an interest in is resolution, and mediation provides you a mechanism for achieving resolution. So let's focus on the thing we're going to do 90 or 95% of the time, which is mediate a case, and spend a lot of time getting good at that. And that's what this seminar was really designed to do, is to help people become better mediation advocates so that they do a better job in the mediation, score better results, engender client trust and confidence. And at the end of the day, I think it will attract and keep, it will allow you to keep and attract more business. I know from personal experience that lawyers that, for example, do insurance defense have started to see the writing on the wall and recognize that the carriers are looking for settlement. They're looking, same thing that plaintiffs bar is looking for, resolution at an effective way. So I think it's incumbent upon every trial lawyer to be a good mediation advocate. I don't think it's enough anymore to say I'm a really good trial lawyer. Well, but I don't really care about settlement. I'm indifferent to it. If it happens to settle, great. I think you have to change your attitude entirely, and you have to be an advocate for resolution and advocate for the mediation process, because the more sophisticated, intelligent actors are going to expect that, I think, going forward. And your ability to earn a living is ultimately going to depend on your ability to do well in mediation, either on the plaintiff side or the defense side. So let's talk about how we get good at mediation. So that's sort of the big picture for me, is mediation advocacy is underappreciated by the bar, by the general public, because the media doesn't report the results. And if you don't have any public spectacle, it's very hard for people to understand the true benefit and greatness of the mediation process. I mean, we can take a complicated case that may take months and years to resolve with a multitude of parties and claims and cross claims and discovery disputes, all the hoo-ha, as my friends like to say, all the hoo-ha associated with litigation. And the amazing thing about mediation is we can collapse all that. We can collapse that thing like a black hole in the universe. We can collapse all that into a single day and reduce all of that to a settlement in a single day. That's a pretty powerful process. And I was trying to figure out, why does mediation work? Why is it that 60 to 80% of the cases that come to mediation settle at mediation? It took me a long time to figure that out. Well, I think for a lot of reasons, because cost, time, delay, certainty. But fundamentally, I think the reason why cases resolve is because mediation allows us to do the one thing that trial or being in litigation doesn't allow us to do, and that's talk to one another. See, it took me a while to figure this out, but trial and litigation, the litigation process, silences the clients. We don't let our clients talk to each other. We don't talk about settlement that much. We talk about all the other minutiae associated with the mechanics of litigation and the scheduling and the hearings and the depositions and the discovery fights, and we don't get to the core of what the thing is all about, which is we have a dispute. Two people aren't talking to each other. They need to resolve their differences of opinion. And we don't do that in a litigation. We don't spend any time doing that because we're so caught up in the machinery of litigation. We don't spend time on the $64,000 question, which is how are we going to resolve this case? And that's the other problem with mediation, is because it doesn't have any rules. It doesn't have any baggage. It doesn't have all the machinery associated with it like the litigation process does. It doesn't have calendar deadlines and dates and 30 days for this and 15 days for this and 20 days to respond to that. There aren't any dates. There aren't any hard and fast rules other than confidentiality. So what happens is mediation kind of gets set on the intellectual back burner. It becomes sort of secondary. to the litigation. It becomes like a timeout, or some used to try as a timeout from the litigation, or as a break from the litigation. I think that all that thinking is very counterproductive. I think trial is a break from settlement discussion. I think the pyramid's upside down because the settlements are abundant. There's 100 times more settlements than there are trials, right? So if we're really talking about what's the most important thing, it's getting the case resolved. That's what's going to happen the overwhelming majority of the time. But we don't have any rules or machinery. We've spent very few, if you're on the defense side, billable hours, right, on your timesheet, thinking about, talking about, moving the case toward resolution rather than trial. And we really got to make a cultural shift in the way that we think about where mediation lands in the dispute resolution system, because it's not inferior, it's not secondary, it's actually primary. It's actually the most important thing that we do as lawyers. And Lincoln said that. Wasn't Abraham Lincoln's quote, be a peacemaker, there'll be cases enough, there'll be work enough, right? He knew that 150 years ago. So trials aren't going to increase. They're resting around, trial rates around 1%. No one's predicting it's going to increase. I don't think anyone's making that argument. I'm not seeing any press. I'm pretty active in the ADR section of the Florida Bar and the business law section of the Florida Bar. And I don't hear anybody talking about an increase in the number of trials. It's hard to increase the number of trials because the marketplace has sort of spoken and said, we're not really keen on trials, because if the plaintiff's bar or the defense bar like trials, there would be more trials because it takes two people to settle the case, but they don't. So the marketplace wisdom, so to speak, is that trials are a small percentage of what we do. It's a last ditch attempt to settle the case. All right, so that's sort of big picture. What's more beneficial to the public, high stakes adversary proceedings or negotiated resolutions that bring peace and harmony and benefits to people? I think you understand now why I think mediation deserves its due. More so than trial. Let's talk about mediator selection and timing. We could do a whole hour on mediator selection. We're not going to do that. There's a couple things that people like to talk about and like to ask about. I like to talk about subject matter expertise. I think in certain arenas that really pays dividends. If you're talking about things that are hyper technical, like medical malpractice or intellectual property disputes, things of that nature, eminent domain, obviously, there's some areas where subject matter expertise is beneficial, but for the most part, subject matter expertise is not all that critical because mediators are pretty good at picking things up on the fly and learning from the lawyers what they need to know about the law that governs the dispute, because the law doesn't tend to be all that hard or difficult or an impediment. In fact, the law doesn't really play much part in the mediation process. In fact, most mediators will tell you, if you're talking about the law and mediation, you're probably not going to settle your case. People make decisions to settle a case not based on the law, then make decisions to settle because they think it's in their best interest. The law just happens to be one of the things that triggers a discussion, but it's not really critical to the ultimate resolution of the case. So mediator selection stuff. I do want you to think about, though, things like gender, race, age. I think those things matter in certain cases. The example I like to give is an employment practices dispute. If you have a sexual harassment case and the harasser looks like me and the victim is a young Black female, African-American female, I'm not sure I'm the right mediator. I don't know that that's the right choice. Maybe you want a woman as a mediator. If there's some level of sensitivity that's required, if it's a privacy case, for example, or something like that, or a defamation case, you got to think real carefully about who you want mediating that case. Same for construction. I know from my experience in construction cases, I treat those very differently than other cases because I know the personalities that are going to show up most of the time. If I talk to the lawyers, I get a heads up on who am I dealing with here. And that there's those folks that work construction and work in those industries tend to be a little tougher cookies than some of the other folks you deal with. And so they can tolerate a little bit more, shall I say, pushback than some other folks might. So you have to know your audience and you have to think of a mediator who's going to fit with that audience. And sometimes you have to shift gears as a mediator. Sometimes you think you're going to use one approach, then you have to shift gears to another. And it's helpful if I have a heads up from the lawyer and ahead of time if there's any particular sensitivities or issues. I had a lawyer tell me just the other day, he said his client doesn't like stories. He says, been to lots of mediations, doesn't like long stories. Well, I have a couple stories. I didn't use my stories because my stories weren't very helpful in the eyes of that client. So it's helpful to talk to the lawyers in advance and get a heads up on who you're dealing with. You also want to make sure you pick a mediator the other side's comfortable with. It's not so important that you love the mediator. It's important that the other side likes the mediator and respects the mediator, because when you give them your last offer, your last demand, and you say, this is it, that's all there is, there's no more. You want that mediator to be able to deliver that message and for the other side to trust that that message is true. And so trust in the mediator by the other side, because it's the conveyor of the message that needs to be trusted. And so it's like a sponsorship theory sort of concept, that the idea the proponent of the last offer adds weight or gravity to the offer or the demand. So you want to have someone who's trusted, because it makes the demand seem more solid and more permanent and more fixed and less subject to haggling back and forth, if that's truly your intent, is to communicate your last demand. Talking about timing a little bit, this is one of my pet peeves, and I think timing is really a problem. Let me tell you why timing is a problem. Most mediations occur too late. I'm convinced to a moral certainty I'm right on this. The reason mediations are late, one of the reasons why mediations are late, well, there's a couple of reasons. One, because lawyers think they need a ton of information before they can mediate. You don't. You need a ton of information, a lot of discovery to try a case. You don't need a ton of information to mediate a case. Second, more compellingly, in Florida in particular, and other jurisdictions, it's even worse. They set the mediation deadline at the end of the case. So you see mediation deadlines frequently that will say, 60 days before the pretrial conference, or 90 days before the trial date, or some back end date that's very late in the discovery or even after the discovery process. Those are all wrong. Those are suboptimal. They're not good, but they persist. And the reason they persist is because it's unexamined habit and ritual. The reason think about it, why are the mediation deadlines at the end and not at the beginning or closer to the beginning? I'll tell you why. You have to know a little bit about the history of mediation. Back in the 1980s, when mediation became the norm, there was some resistance. It was new, it was kind of funky, nobody knew what it was, and the trial lawyers were a little skeptical of it, some very skeptical of it, and they viewed it as a threat to their livelihood, which is kind of sort of true, because it was designed to create more settlements, fewer trials. And so when the judges started implementing mediation as a thing, as a mediation order, in order to placate what they perceive would be some pushback from the trial bar, they put the mediation at the end of the process. Because if you've got resistance, if you're anticipating some resistance, some hostility, some pushback, you don't want to make mediation the first order of business in your case management order. You want to put it at the end. So it was a psychological ploy to deflect the early objectors to mediation back in the 1980s, in the mid-80s. Mediation became a standard thing after the adoption of the Mediation Confidentiality and Privilege Act in 1985. So in the late 80s, mediation orders came about as part, or mediation was ordered as part of a case management order or a trial order. And that sort of historical fact that the judges wanted to put the mediation at the end to placate the objectors, that continues to this day. That no one's ever changed that. But there's not any studies showing that the mediations are better at the end. There's no data showing that mediations cases settle more frequently at the end. There's no data suggesting when the optimal time is, because if you have mediations at the end, you've built up a lot of animosity, you've built up a lot of sunk costs, you've created a lot of hostility. At the beginning of litigation, people tend to be, they might be hostile, but they're not as hostile as they are 6 months or 9 months in, when they've been called names in deposition and they've had to suffer all the slings and arrows of the trial, of the vicissitudes of trial, right? So salvaging relationships and getting benefits in the hands of people earlier would seem to make more sense, rather than let the thing sort of brew and get more toxic, right? It's going to get more, generally speaking, litigation tends to get more toxic over time, not less toxic. Agreed? So if we know that reality, and we know that sunk costs become a psychological impediment to settlement all the time, we know that every study on, the buying and selling of stocks and investments, we know people hold on to things even though they shouldn't, because they have a psychological, they're anchored to it. And so early mediation is a good thing. I recommend, and I started recommending at the end of my career when I was a litigator, I would start putting 2 mediation dates in the case management plan and proposing one early, say within 90 to 120 days of joinder of all the parties, and another one later in the discovery process. And every time I suggested this to the opposing counsel, they agreed that was a good idea, because it is a good idea, because you want to give client a chance to settle the case early before you spend a lot of time and energy and money on the case, and then give them another one later on, because you don't want to have to ask for a second mediation, right? If you ask for a second mediation late in the case, that may signal a little bit of weakness. And so folks don't want to signal. Well, if you agree to 2 mediations in advance, think of that, it's fantastic, because it's not signaling anything other than we're going to have 2. The first case, the first mediation, if it doesn't fail, if it doesn't work, okay, fine. We don't have to go to a second mediation if we don't want to, because the court's not going to make us do it. So if we decide later in the case we don't want to mediate a second time, we don't have to. But if we need that second mediation because the case hasn't gone in the direction that we want, or the client's got cold feet, or the client's run out of money, I can give you 100 reasons why people's litigation posture changes. If you need that second mediation, you've already got it on the books. So I think it's a real clever idea to get your mediation scheduled early, because you don't want to wait till late in the litigation process when you're up against discovery deadlines, trying to cram in a mediation, which I frequently get those kind of calls where, hey, we're up against the deadline. Dave, can you do a mediation for me next Thursday? That's hard to do. So it's much better to think about that early in the process. And even if you can't agree on the second date, at least make it clear we're going to have a second one, and maybe hold a date or something like that, put a loose hold on a date, so you don't have a scheduling hassle, particularly in multi-party litigation. Hugely important in multi-party litigation. Your construction defect, your med mal, all those kinds of things. The cases can change, fortunes can change. The appetite for litigation, particularly in business litigation, can change. And in personal injury litigation too. The claimant may be, all perfectly willing to go to trial and hold out for top dollar. And then they find out they got a sick kid, or they got a parent they got to deal with, or they got a job relocation, they got to move out of state. I can give you 100 reasons why people settle cases that don't have anything to do with the merits of the case. It's true on the defense side as well. Maybe there's coverage problems. Maybe there's a rogue employee who's not going to testify for us. Maybe there's a bad document that's about to come out in discovery. So in any event, timing is really important, but please, I'm urging you, think about scheduling mediation earlier in the life of the case. And even if it doesn't settle, a mediation is not a waste of time. A mediation is not, an impasse is not a failed mediation, because you're going to learn information. You're going to hear things you hadn't heard before. You're going to get some free discovery. You might find out early with an early mediation, heck, there's another party I need to join, or I've got an affirmative defense I didn't realize, or maybe there's another element of damages that we hadn't considered as plaintiffs. There's a number of things you can learn from an early mediation. It happens all the time, changes the course of the case, because the interaction between the mediator, the lawyer, the client, just thinking about that problem for 4 or 5 hours during a mediation, you start to generate new thoughts and new ideas. Because think about it, in your normal litigation practice, how often do you get to spend 4 or 5 hours just thinking about one problem? Almost never, right? I mean, that's one of the beauties of mediation, is you're sort of cut off, you're sequestered, so to speak, from the other files. You're not bombarded with phone calls and emails and all the other distractions. And so if you can just focus on one problem for 3 or 4 or 5 hours, chances are you're going to come up with some ideas about what to do about the problem if it doesn't settle. So you'll come up with some new defenses or some new causes of action, or maybe you'll find out you need an expert in some area you hadn't anticipated. And all that comes clean at the beginning of a mediation. You might also find out that the plaintiff is crazy, or the defense has got real problems, and it may give you some strategic insight into what you need to do to get the case resolved. So you might not settle the case at early mediation, but you might put yourself on a path where it becomes easier to settle the case down the road. Or you can narrow the scope of the litigation. Maybe you had some wrong ideas about certain theories that you touted and you thought were true, and very quickly you learn, without a whole lot of depositions, without a whole lot of time and money spent, you're going down the wrong path. That theory is not going to fly. You need to switch gears. So that could be hugely important. We're going to have, this is course 1 of a 10-part series, as I mentioned before. Course 2 will come at the top of the hour. We'll switch gears then. So we talked about timing, we talked about selection of the mediator, and we talked about there's some hesitancy to engage in early mediation because there's this belief that you got to have perfect information. You don't need, you can't get perfect information. You're never going to know everything. But people make decisions, important economic decisions, based on imperfect information all the time. Everybody does. When should I have a kid? Should I open an office here or here? What dishwasher should I buy? What car should I buy? I don't have perfect information. I do some research and investigation. I make my best guess and I live with it, right? Settling a lawsuit's no different. You need some basic information on damages. You need to know what the key defenses are. You need to know what the major theories are, right? You need some sense of what the best case, worst case might be for you. So you've got to crystallize the damages on some level, right? But beyond that, you don't have to have 10 depositions to settle a case. I've had wrongful death cases. We settled very early on without virtually no discovery because we knew we had a liability problem. And we didn't have to wait for the plaintiff's deposition to tell us that they really were grieving the fact that their young son had died, right? I don't need to hear mom and dad cry for 6 hours about their deceased son. I don't need to make them wait 9 months or a year and a half to get paid. That's just going to make it harder. We know that from studies in the medical malpractice arena, for example, where we know that if the doctors in the hospitals get to the patients earlier, say they have a bad baby case, if they get to the patients sooner and they apologize and tell them what the corrective action is going to be and get in front of that case early on, frequently you can get a better deal. And that's true in transportation litigation. I've done that for aviation accidents where we had multiple decedents. If we can get out in front of this thing when we know we have a liability problem, or if we don't have a liability problem, educate the plaintiff's attorney so they know there is no liability problem. The liability is very doubtful, and try to educate them. Sometimes we can broker a very inexpensive settlement in what would otherwise be an expensive piece of litigation. So thinking about timing and mediation is hugely important, and convincing people to go to an earlier mediation is almost always a good idea. You're almost never going to end up, you're going to end up with something. You're going to end up with more information, strategic value, insight. I'll give you one quick example. Had a construction case, mediated fairly late in the case, should have mediated sooner. We're $75,000, $100,000 apart. There's a contractor and a sub, and there's a fight between them over bad construction. And finally, in probably 6 hours in the mediation, the subcontractor tells me and his lawyer that he is dying of cancer and he likely won't be around for the trial. Never told the defense lawyer that. Carrier didn't know. So obviously, if he's not going to be around to testify, it changes the whole dynamic of the case. And the lawyer finds out about this now at the 6th hour of the mediation, 9 months into the case. And you say, well, why didn't the client tell him? Maybe it never came up. Maybe the lawyer wasn't spending a lot of time on the file. But if that information had got out there sooner, that this guy was really sick, it could have made the case a lot easier to resolve sooner and cheaper rather than incur a bunch of litigation expense that end up being wasted because that case was not going to be tried. So you never know what you're going to learn in mediation. There's always some surprises, not always, frequently there are some surprises, some things outside the four corners of litigation that are driving that case. Number of different things drive that case. You'd be surprised the number of things that cause people to settle cases that don't have anything to do with the merits of the case. And early mediation allows you to find that out. Let's talk a little bit quickly about some problems with the federal court rules, and we'll deal with some more of this in course number 2. But I want you to make sure that you understand some of the case management orders that order mediation in federal court have bad faith or they have good faith requirements. I want to mention that for a second because those good faith requirements are sort of illusory. There is no such thing as good faith or bad faith in mediation. And the reason I say that is because in Florida, if you're a certified mediator, you can't report instances of good faith or bad faith. You can't report bad faith. So if the court order says parties have to participate in good faith, and if they don't, they're going to be sanctioned. Well, how's the court going to find out that there was bad faith during the negotiations? The only way you could know that would be to somebody say what happened during the mediation. Of course, we have very robust mediation confidentiality and privilege. And there's 6 exceptions under the statute to the confidentiality rules and the privilege rules. Well, statements evidencing bad faith are not an exception to the rules governing confidentiality. So there's almost no way to report. But I make this point because I think the federal courts do a disservice to folks when they say you have to mediate in good faith, because that term of art may have some meaning in some other jurisdictions. They may be enforceable because they have different mediation rules and reporting and things of that nature. But in Florida, saying you have to mediate in good faith is really just kind of it's sort of intellectually flawed, because you don't have to mediate at all. All you have to do is show up. If you don't want to entertain any offers, if you don't want to make any offers, if you don't want to respond to offers, you don't have to. All you have to do is show up. You can leave in 5 minutes. I don't think people understand that. There's nothing I can do to compel you to stay. And the other thing you'll see in some of these orders, you'll see it says, well, the mediation continues until there's a declaration of impasse by the mediator. Well, that's technically true, but what you also need to know is that I don't control when you leave, because if you want a declaration of impasse, I have to give you one. I'm not ethically permitted. I'm not some school patrol or some police, some cop that says you can't leave, you're under arrest. No, if you want to leave, if you're tired, now I may talk you out of it. I may say, hey, I think there's some more to talk about here. Why don't you, because I've had that happen plenty of times. People say, well, we're not going to make a deal here today, or, that's a ridiculous offer. I should just leave. You see that all the time, but I can't force you to stay. So if you want a declaration of impasse, I have to give you one. And so you need to know that, because some of the case management orders that I see don't really make that clear. And it makes it appear as if the mediator can hold you hostage. And there's some mediators who think that they can. There's some mediators who will tell you how long your opening session should be. There's some mediators who will tell you whether you can have an opening session or you can't have an opening session. And in Florida, of course, the common practice is to have a joint opening session. But if you go outside the state of Florida, I'll tell you that's not always the case. But it's not up to the mediator to decide how long you talk, or the method of the way you talk, or whether you use a PowerPoint or not, or how long your PowerPoint's going to be. Mediator doesn't get to control any of that. So if you get a mediator who's limiting your time in some way, you need to politely tell them that's not kosher. That's not correct. You don't get the liberty of doing that. All right, so that's some of the problems with mediation orders in federal court. All right, we're shifting now to course number 2. You got through the first 30 minutes. Thank you so much. We're on to course number 2. As I said before, this is a 10-part series. We're going to present this in 5 one-hour segments. They're going to be recorded between now and the end of September. All the dates and times and Zoom links will be on my website, and there'll be additional emails coming out with reminders for those dates. The next one of these seminars will be on August 24 at 3:30, and we'll do courses number 3 and 4. Okay, course number 2, thank you for attending. This is attendance rules for parties, and we'll talk about virtual attendance. And I want to get these out there to you because I think we have some confusion over what are the rules governing attendance of the parties and special situations involving carriers. So we all know in Florida we have Rule 1.720C, which says you're going to certify that the person coming has authority to settle on behalf of the parties, and if there's insurance involved, you have to certify that the party has authority up to the policy limits or the last demand, whichever is greater, or whichever's less, excuse me. What happens if a party lacks authority? What if during the course of the mediation process, somebody says there's a demand of $750, the party on the other side tells the mediator, I don't have authority for that. I can't get there. I don't have authority for that. I need to call somebody and I can't get that person on the phone. So what, and suppose the other side finds out because there's a chat in the hallway, or the mediator has a slip of the tongue, or somebody just blunders it out, just says, I don't have authority for that. And the other side learns about that. They don't have authority as required by the rule. What can you do with that information? Well, it only becomes a problem when the case doesn't settle, right? Because the classic scenario is the case doesn't settle, and then one side gets upset that because the other side didn't bring all the authority that they should have thought they were going to bring. And the one side, usually the plaintiff, wants to bring sanctions against the defendant. And so they'll tell me at the end of the day, when it's clear we're not going to settle, that I'm going to bring a motion for sanctions because I don't think they have the right authority. And I always stop them right there and I say, how are you going to prove the presence or absence of authority? Well, he said during the mediation that he didn't have authority for that. Or you told me, Henry, he didn't have authority, which I wouldn't do because I would use different language. But if he finds out that there's no authority, what can he do with that? Nothing. Because if you start testifying or put in an affidavit, support your motion for sanctions, statements that were made during the mediation process, you're going to be violating the Mediation Confidentiality and Privilege Act. So the funny little irony here is that the rules require that you have authority, and they explain what authority means, but there's really no good mechanism for enforcing that rule, because when they adopted the certification rule and under Rule 1.720C, they didn't modify the exceptions to confidentiality. So statements tending to prove the existence or absence of authority are not one of the enumerated exceptions to confidentiality. There's no exception for that. So I've told counsel, I said, if you file the affidavit that I think you're going to file, you're going to be sanctioned because you're violating the Mediation Confidentiality and Privilege Act. And I know this because the drafters of the rules were cognizant of this problem. I talked to one of them and he said, yeah, we talked about that on the committee. And we knew there was a problem, but we didn't want to go to the legislature and raise that raise that issue and start talking about exceptions to this confidentiality. So we just kind of ignored it. So it's a little, nudge, nudge, wink, wink, kind of a, we know there's a rule out there that says you got to have authority, but there's really no good mechanism for enforcing it. And so you need to know that if anybody starts barking to you about your client not having the requisite authority, there's really nothing you can do about it. There's a practical fix, and the practical fix is you need to do a good job of educating the other side so they bring enough money to settle the case, right? You didn't do what you need to do to get them sufficiently intimidated or fearful of their exposure, if it's a defendant problem, to settle their case. The other thing you can do if you're on the defense side is make sure you have key decision makers. If you have if you're an individual plaintiff, it's easy. But when you have a corporate plaintiff, it's very important that you get the key decision maker to the mediation. Mediations that lack key decision makers have a higher impasse rate, and that shouldn't come as a surprise to anybody. But it's pretty important that you get the key decision makers, and I would say the true voice of the corporation. Here's another question that frequently comes up. Who is permitted to attend? I had this happen the other day. Someone started barking and fussing because there was somebody in the room that they didn't think should be there. What's the rule? Well, there is no rule. You can bring anybody you want to mediation. Contrary to popular belief, mediation is not limited to the parties. If you read chapter 44, it speaks of mediation participants. It doesn't speak of parties. It says participants. You can bring anybody you want to mediation. If the other side objects, the mediator does not decide whether the person stays or goes. That's not the mediator's role. If someone objects to participation, they got to file a motion to have that party excluded. They got to bring it in front of the judge. So, of course, the obvious practice habit that you should implement is to call the other side or email the other side in advance and say, who you bringing? Now, 99 times out of 100, it's not a problem. But every once in a while, I go to a mediation and we spend the first hour arguing about who's going to be in the room, right? And that's because we didn't notify each other in advance. So I tell people in my engagement letter, if you're bringing somebody who's a non-party, you need to let the other side know in advance so they have an opportunity to think about it. A lot of times there's knee-jerk reaction when somebody brings somebody else. There's knee-jerk reaction, no, they're not here, they shouldn't be here. Frequently, though, I can be able to talk the objecting party off the ledge and say, look, they brought their niece. Maybe it's an elderly person, and they want someone there to help them make their decisions. They want a younger niece or nephew or brother or sister. That's perfectly fine. Sometimes they bring an expert with them to help do a presentation on damages or liability. That's perfectly fine too. Sometimes they bring an accountant or a CPA if there's some economic damage issues or there's some tax issues that they got to deal with. So you can bring anybody you want to, but it's incumbent upon the parties to agree that that person can be in the room. It's not up to the mediator. And if there's a dispute, you need to get that in front of the judge before the mediation rather than on the day of mediation, because the mediator does not have the power to make decisions about attendees. And people are going to want the mediator to do that. And if the mediator is acting appropriately within the guidelines for certified mediators in Florida, the mediator will not step into that fight. When I had that happen the other day, I told him what I just told you, which is that under the law, you're allowed to bring anybody you want to. And if there's an objection, it has to be resolved by the court. That's all you need to know about the law governing participation. And if you're going to object, you've got to have pretty compelling reasons, because the number one sort of, the sine qua non of mediation is self-determination. And if I'm depriving you of people who are going to help you make your decision, then I'm affecting your decision-making ability, or maybe you're fearful of the process. I'm interfering with your self-determination, and I don't want to interfere with self-determination by saying you can't bring somebody to the mediation. So very important that you get that resolved early. Again, 99 times out of 100, it's not a problem, but as a practical matter, a good practice habit is to simply ask the other side, who you bringing? And that way you can get out in front of that problem early on. Let's talk about attendance rules in federal court for just a second, because there are some quirky little rules in the northern, southern, and middle districts, and they're not the same. So there's some attendance issues and some other kind of strange little pieces and parts that I want to bring to your attention. So the Southern District has more specific rules regarding attendance and preparation than the Middle and the North. In the Southern District, the parties are submit confidential statements to the mediators 14 days prior to the mediation. That's local rule 16 to DC in the Southern District. The Middle District doesn't have anything, doesn't say anything about submittals unless it's in the case management order. There's nothing in the Middle District rules that speak to when if you send submittals, but the case management orders will normally say you send a summary 7 days in advance or something like that. That's in the case management order, but not in the rules. Interestingly enough, and this is a problem that I've been wondering about and talking about a little bit, in the Southern District rules, they expressly incorporate by reference the confidentiality of Chapter 44, specifically Section 44.405, which is, of course, the Mediation, Confidentiality, and Privilege Act. So the Southern District says these are going to be confidential and privileged proceedings under Chapter 44. Curiously, the Northern District and the Middle District do not have any such rule. And if you read the case management orders that come out in the Middle District or the Northern District, they will not refer to Chapter 44. They'll say privilege or they'll say confidential. They're confidential settlement discussions, which of course is the evidentiary rules governing settlement discussions, are very different than the mediation privilege. So saying they're confidential settlement discussions means you're talking about rules of evidence. My point is, you want to make clear when you go into a mediation that the mediation is governed by Chapter 44, assuming you want all the robust protections of the statute. The case management orders and the local rules in the Middle and the Southern Districts curiously don't make mention of that. Now, I think as a practical matter, everybody treats it as if it's a confidential and privileged proceeding under Chapter 44. And I fixed that problem because in my engagement agreement, I tell you that I'm mediating under Chapter 44. So there's no question about that. So you know you're going to get that. Even if it's a pre-suit mediation, you're going to have Chapter 44 apply to the mediations that I do. All right. A couple other quirky little rules that you'll find that are worth commenting on just briefly. In the Middle District, they have a rule that says, I think it's 4.01. It says, you can have attendance by a party or a surrogate acceptable to the mediator. Nope, can't do that. I don't get to decide who is an acceptable surrogate for a party. That's not something I can ethically do as a Florida Supreme Court certified civil mediator. I don't make that call. If somebody shows up in place of the plaintiff, they're satisfactory. Plaintiff can send or the defense can send whoever they want to send. Again, it's back to then the other side has to object and say there wasn't proper attendance. But we can't, the mediator cannot be in the role of calling balls and strikes, that is to say, making decisions about who's going to be there or how they're going to be there. That just doesn't comport with mediator ethics. There in the Northern District, there's no specifics apart from the ordinary attendance rules. There is a local rule that provides, it said everything said during a mediation settlement conference other than the terms itself is confidential and inadmissible as a settlement negotiation. That's local rule 16.3 in the Northern District. But again, it says as a settlement negotiation, that's not the same privilege as the rule 90, was it 90.408, 407, 408? Settlement discussions, that's an evidentiary rule. That doesn't get you the same level of protection as Chapter 44, not by a long measure. So I think that's an oversight in the local rules in the Northern District. A couple problems with case management orders I want to mention. Frequently, they do require submittal of papers to the mediator within 14 days. What they don't say is they don't say you should send your mediation statement to the other side. I'm a big proponent of sending your mediation statement or some version thereof to the other side to educate them. I think that's hugely important. I don't think it's good to hold back information. Oftentimes parties will send it to me confidential, say it's not to be shared, and then they spend the first 15 or 20 minutes in the opening session saying all the stuff that was in the mediation statement. Well, why wouldn't you give it to them in advance? Why wouldn't you want to have them hear all the bad stuff and then hear it again so it starts to sink in? Why make it a surprise? You want to educate them on the key themes, whether it's liability, damage claims weak, witnesses are a problem, whatever the defenses or claims are, you want to educate the other side. And you want to continue to reinforce those ideas and notions and facts and principles. And why do it just once? Get it out there in writing in advance early so they have time to evaluate it, to test it, to see if they agree with it, that sort of thing. I had a plaintiff's lawyer tell me one time, he said, David, we love it when the defense sends us a mediation statement because then I don't have to be the bad guy with my client. I'm going to say, this is what they're going to say. If I'm the plaintiff's attorney, this is what they're going to say about you and your case and your claims and your injuries or whatever it might be. I don't have to beat up on my own client. The defense lawyer's done that for me. So it helps me get client control. Think about that, right? You're doing the plaintiff's lawyer a favor by sending them a mediation statement because it helps him or her get leverage over their own client. It manages expectations. If you don't send them all the bad stuff, and you only tell them the bad stuff in the mediation, the client may not be in a position to intellectually and emotionally accept it. You got to be intellectually and emotionally prepared to compromise your case. And the way you do that is to start educating them on where the problems are, and not necessarily problems with the case. You can talk about things like how long it's going to take, the uncertainty of juries. There's a number of different themes. I do a whole presentation on how you draft an effective pre-mediation statement for the other side. I think we'll cover that in one of the later sections. But we're focusing on the case management orders that we get. Some CMOs are starting to have earlier mediation deadlines, but most of them are going to have those late mediation deadlines that we talked about. Some CMOs permit the mediator to excuse attendance, but again, this violates ethical standards for civil mediators. I don't have the power to excuse attendance. I do want to mention that because that comes up from time to time, particularly in the insurance defense arena. We see where the insured, who has, maybe it's an simple automobile accident case, the insured driver is excused from attendance because we know that the carrier is going to stroke the check and there's no contribution coming from the defendant. Technically, that's a violation of the rules because the parties don't have the ability to excuse attendance. The mediator doesn't have the ability to excuse attendance. What the safer practice would be to get an order from the court, get an agreed order from the court, just a quick little order that says, Joe Blow is insured. The claim is within the policy limits. We don't believe everybody agrees the insured's presence is not necessary to effectuate a settlement. The mediation process will not be hampered by the defendant's absence. And then the judge can sign off on that order. Now, where that becomes a problem, and I had this come up the other day, where that becomes a problem is twofold. Once, where there's something in the deal that is non-economic that the defendant must agree to. You have to agree to do this, and you have to take down that sign, or you have to agree to non-disparagement, or you have to agree to confidentiality. You have to agree to something that's not economic. That's something you have to think about. Second, where there's an excess verdict scenario. I think it's very dangerous for defense counsel to excuse a defendant when there's an excess verdict scenario. If the case doesn't settle, the defense can say, I wasn't made aware of what the demands were. I would have insisted that the carrier settle the case. I would have done some things differently. I would have personally contributed. You didn't give me the opportunity to personally contribute to the settlement. So there's a myriad of things that can go badly. Now, again, it's not a high probability event. Doesn't occur very often. But if you're going to excuse the insured defendant, you better make sure that none of those things that I just mentioned could possibly happen. There's never going to be a demand in excess of the policy limits that the carrier is going to, refuse, and there's never going to be any non-economic terms. So it's not a good idea to excuse a defendant. Plus, the other point I make is that a lot of times the defendant will give you information during the mediation that they didn't give you before. They forgot to mention it. They did when you were interviewing them and talking to them. They forgot about it. They didn't think it was important. I can't tell you how many times someone has said something in mediation their lawyer's hearing from the first time. Maybe it's the name of a witness. Maybe there's some photographs. Maybe there's some other evidence that the client is aware of that they didn't mention before. They go, oh yeah, I have a database that has some backup information and I forgot about that. Well, that's hugely important, right? So I think it's really bad practice to excuse the defendant. And I never did that when I was in mediation. I never excused my defendant. The only time I did it, I take that back. I think I did it one time when my defendant was accused of some very snarky misconduct, very snarky, sexually tinged conduct. I don't want to get into the facts, but I didn't want the defendant in the room. I guess the exception would be if the defendant is fairly loathsome and might be upsetting or off-putting to the plaintiff. You don't bring them, or at least you don't bring them in the opening session. You can put them back in the private caucus. That's probably the better way to handle that then, so that they're there and they hear what's going on, but they're not in the opening session. They don't impact that. Okay, let's talk very quickly about use of virtual platforms, because that's how most of you are mediating now. We've seen a little bit of a comeback to in-person, but because of the just time, travel constraints, particularly for insurance defense arena. The claims representatives typically are located outside the state or in other parts of the state. They don't want to drive or fly. Makes so much more sense. It's so much more cost effective to do it by Zoom. So I think Zoom is here to stay. I don't think we're going to go back to in-person in a major way unless all the actors are there. I think you're going to see increased use of Zoom technology. Most of the mediators, and I've done some surveys on this, most mediators report that they feel they are just as effective or nearly as effective as they would be in person, and they don't think their settlement rates are adversely impacted by using Zoom. I do like in person when I have a business dispute between, for example, former partners, a corporate breakup, what I call corporate divorce. Everybody's in town, everybody knows each other, the lawyers know each other. Those are the kind of cases where I feel like the energy in the room is better if I can move between the rooms in real time very quickly and I'm there with you. And there's a psychological, I guess the word would be leverage or psychological attraction or psychological investment in the process when people are participating in an office setting. They feel more invested in the process. I think that creates a certain desire for the thing to settle. I think there's some kind of attraction that happens when people are in the room. They don't want to deal with this person, so they're feeling like the proximity makes them uncomfortable, and so it's that uncomfortableness that makes them want to settle the case, if that makes any sense. Like we had to sit in an office with these guys for 6 hours. We don't want to live with them in litigation for anymore. But if you're remote and you're in your comfort of your own home or office and you're not physically there with the people that you dislike, it's easier to pull away and say, no, I don't want to make that deal. So I think it's a little easier to walk in a narrow category of cases. But I think overwhelming majority of mediations and mediators will say no effect, no real effect. But let's talk about the use of virtual platforms. I have an article on this called The Convention of the Witch and the Princess, which is on my website. You can read. I have a blog called the Mediation Minute that comes out every month. And one of the blogs I wrote a few months back is called The Convention of the Witch and the Princess. And it's this idea that, in television and movies and books, there are conventions about how witches look and how princesses look, and princesses have bright colored clothing and they're well groomed and they put on a good appearance and they're viewed as more virtuous. And the folks that are not virtuous, the witches, are dark and gloomy and they appear in monochromatic colors and they have their appearance is oftentimes not very good, homely or disfigured or things like that. And we have these conventions that have gone back through literature for centuries and in the movies and books, et cetera. And so you want to play into those conventions, so to speak. You want your audio and your visual to look good. Now I have the camera setting on maximum improvement. This is as good as it's going to get, but I think about my virtual background. What do I want it to look like? I think about my lighting. I bought a little portable light, and if you email me, I'll give you the Zoom link or the Amazon link. But I have a little sophisticated, it's inexpensive, but sophisticated portable light that I can adjust the brightness on. I can adjust the luminosity on, and it works very well. And it's very lightweight and cheap. And I travel with it when I'm doing mediations in somebody else's office. So I think quality audio. Now there's some local rules that have been coming up that say you got to have audio and visual. So some people appear on Zoom, they turn their cameras off. That's not allowed in some jurisdictions. So some local rules, I think the Southern District has a specific local rule on that. It says you have to have operational audio and video. And as a practical matter, it's only fair because if one side's participating by video and the other side's not, well, you're not participating in a balanced and even-handed fashion. The mediator has a job and a responsibility under the ethics rules to make sure the mediation is conducted in a balanced and even-handed manner. And that's not balanced and even-handed, because if I can see you, but you can't see me, I have an advantage because there's non-verbal cues that you can pick up when you watch somebody. You can see how they're reacting to your position, how they're reacting to your statements, whether they're upset or whether they're happy, whether they're confused or whether they're pleased. You can't get any of those visual cues if your camera's not on. So what you're seeing slowly is courts coming to the awareness that if we're going to allow you to appear by Zoom, you actually got to appear. I mean, you got to be seen. So make sure your camera looks good. And psychologically, you want your lighting to be good and your camera angle to be good because it makes it more pleasant for the mediator to do business with you. And the mediator's not struggling to see you or hear you. And that creates a psychological bond that's favorable to you. I mean, you all know this. When someone's audio is halting or screeching or sounds bad, you don't want to listen to it. You don't want to pay attention to it. You just want it to end so you don't have to listen to it anymore. You've been on a bad phone line, you know what I'm talking about, right? Same concept. So you want your audio and visual to be the best that it can be and the most pleasant. This is particularly important in the personal injury arena because too often I will see that the claimant is at home and not in a lawyer's office, and the claimant is unsophisticated, ordinary Joe Schmo, not dressed up, lighting's not good, audio's not good, camera's not good, and I'm thinking, what message does that send to the other side? That you're indifferent, that maybe you don't care so much. You need to spend a little bit of time. If you're a claimant's attorney, I will tell you, it really helps if you make your claimant the princess, not the witch, right? Make them look as good as they can look, put some time and effort to it, call them ahead of time, find out what they're going to wear, find out what their camera looks like, do a dry run on the Zoom call and fix the problem. Again, you can ship them a portable light. You can get one of these little portable lights for, $50, $60 on Amazon, and then have them return it to you when they're done, and you can ship it out to your next client. So lighting shouldn't be an issue. Make sure the camera angle is correct. Some of them are appearing on their iPhones. I've had claimants appear on their iPhone driving a car with their kids in the car. Now, what kind of nonsense is that? What message does that send to the other side? Not a good one. Not a good one. So you really need to police that audio visual presentation in advance, because one of the things I like to do as a mediator, if I'm trying to close the gap on a case, I'll ask the other side, what do you think about the other side? What kind of appearance does the claimant make? If they make a good appearance, I can usually get more money, right? Don't you think there's some value? Don't you think this is a better than average plaintiff? Don't you think they're going to appear better than most plaintiffs? Yeah. So maybe we need to put a little bit more money on the table. Right. Take that into consideration. The lawyers frequently will mention that to me. This is an A, this is an A, this is a B, this is a C minus, this is an A+ plaintiff. This is a gold star plaintiff, right? So you want to spend a little bit of time. It doesn't take a lot of time, but you want to make sure that they are not slovenly, that they are well presented, that they're wearing appropriate clothes. It looks like they're serious and intent upon making a deal. And do not allow clients to appear on the cell phone unless it's absolutely necessary. They should have a laptop. Okay. Couple other things with attendance that we mentioned briefly, and then we'll wrap this up. Motions to prohibit attendance. What rule applies? 1.72a. There isn't really a clear rule on how you excuse someone or what the grounds are for demanding someone be excluded from the mediation. There isn't any real rule on that. I think the cases that I've been involved in, the argument has normally been that the person may have some collateral interest in the litigation, like they have another pending case that's related to this one, and someone wants to listen in, like another lawyer wants to listen in, or there may be somebody who is affiliated with another party that they don't want, and they don't like that affiliation, like a competitor in a business dispute, for example. They don't want that other person listening in because they might get privileged information that provides some competitive advantage. So you got to have a pretty good reason for excluding someone, because the default position is you can bring anybody you want to. There's no rule barring attendance. There's no rule limiting it to the attendance of the parties. So if you're going to say they're a non-party, I don't want them there. That's not enough. That's not, the fact that they're not a party is not enough. Now, it might be for some circuit court judge who's not familiar with the law or the rules. That may be just enough for a circuit court judge. But I'm telling you, it's probably you need a better argument from that. If the judge understands what the mediation rules are, they will know that you can bring third parties. I've had people bring their pastor. I've had people bring a friend, a relative, an expert. All those things are permitted. So be thoughtful, be mindful of who's coming to the party. Focus on getting the key decision makers there. Ask who's coming in advance so we don't have this problem at 9 o'clock in the morning. And if you have to file a motion, try to get that motion heard in advance of the mediation. In advance of the mediation date. That concludes the first hour. Unless there's some questions or comments from anybody in the audience, this will conclude the first hour of the Mediation Mastery Series. Thank you for attending. The next presentation will be on August 24th at 3:30. We'll be taking this will actually be a fun true-false exam on mediation ethics rules. We'll do like a little pop quiz, and then we'll go over the answers. And then we're going to talk about best practices for preparing plaintiffs, defendants, and insurers for mediation. So that's courses 3 and 4 on August 24th. Thank you so much for participating. Hope you enjoyed it, and take care, everybody.